Welcome to the Situation Zoom. And today I've got the suits in the Zoom. We've got the lawyers here to answer some of your questions and some of your potential sticky situations. When the market shifts, we know what happens. Deals fall through, tenants stop paying rent, employers start making cutbacks, and suddenly everyone is an expert on the law. And my lovely panel today have probably been inundated with extraordinary requests, whether it be regarding employment, whether it be regarding contract law. We're going to cut through the noise. I've got some of the sharpest legal minds operating inside the UAE's real estate landscape, and they're all members of the Emirates Legal Network. Joining me is Majdel Musa, no stranger to Golden Nuggets. She was in the first season, if you go way, way back. And then we've got Ammar Al-Banna, who is the founder of Incept Legal, and also Ahmed Al-Nagar, founder of Al-Nagar. Going to get a lesson in how to pronounce this, because actually we're all L's, but apparently I just learned we're not supposed to pronounce the L. Even in my surname, it's Adawi. In Arabic, my surname is Adawi, and you're supposed to be Al-Nagar, and we have Ammar Al-Banna.
Mine's is the lam al qamariya. You pronounce the L. We try to keep it confusing as much as we can, Sylvia.
So for today's Arabic lesson, Majdel, what were you trying to explain to me before?
I was explaining what Ahmad just said, that there are two types of letters. There's the Shamsiyya letters and Qamariya letters. So the ones considered Qamariya, you don't pronounce, or you do pronounce the L. So Al-Banna would be pronounced that way. But the Noon is actually a Shamsiyya letter, so you don't pronounce. So it would be Al-Nagar or Ad-Dawi instead of Al-Dawi. So yes.
Got it. Okay. Ahmed is also a podcast host. Check his show out. It's called The Jurist. And we'll leave the link to his Instagram down below, because he's posting some cool stuff constantly. So definitely be sure to follow him. Without further ado, let's get into it. Right, guys. I want to go to Ahmed first and ask you, what is probably the most common question you've been asked?
Well, thank you so much for hosting me and for the opportunity to speak to your audience. It's a pleasure. I'm Ahmed Al-Nagar, and the most recent and common question that I've experienced throughout the last few days was how to get out of a real estate transaction. And this happened a lot, where people have already signed up for the Form F, the very famous sale and purchase agreement, to go in a deal. And then they realize that the market is not so stable. They're not sure what the future will bring, and everybody wants to get out of the contract. So when I get it from the buyer side, I get, how can I get out of this contract? And when I get it from the seller side, is always that the buyer is delaying and is running around, not wanting to come and sign. This is probably the most common recent question.
So we will come to that. We will get the answers to that. Ammar, what have you been hearing, or what's the main topic that you've had to deal with recently in the last 2 months?
It's actually a mix of bags. We're similar to Ahmed. We've been receiving some of those inquiries as well. And to be honest, we've been in touch with some of smart investors in relation to how they can restructure their deals. So we managed to discuss on a case-by-case let's say out of box scenarios in these situations. We've also seen a lot of persistence in the market. We've seen some investors not pulling out their investment. More to advising almost 1 million dirham project in the entertainment industry, and the deal is still going on. We've seen others pulling out and trying to enforce force majeure questions. On the employment sphere, we've also seen a lot of employers trying to deal with the situations. And some of them would consider redundancies, some of them would consider delaying onboarding process. And it has an impact on the also league stage, right? Because it's a domino effect. Once that happens, you see things falling through. We've also seen all of that, and I would say in the F&B and the entertainment business, I think the major impact was there. It was like instantly. So these are the type of things we've seen in the past 2 months.
How about you, Majdel?
Same as everybody else. So force majeure, people went from not knowing that phrase at all to becoming, like you said, a legal expert and saying that it applies. So I had a lot of questions about that, and from brokers and even buyers directly, to the point where after a couple of weeks, I wrote a LinkedIn post and then I just started sending them the link so that they could read it.
So, for the benefit of my audience, can we just squash the force majeure segment of this episode? Because we're not going to, it's clearly not a force majeure scenario, but can you just explain why and what would need to happen for it to have been considered a force majeure scenario?
So force majeure in the UAE, so basically force majeure as a concept, wherever it is in the globe, it is a major event that was unexpected and outside of the control of the parties to the contract. So it's usually something like war, could be a natural disaster, even nowadays after COVID and pandemic, etc. But specifically in the UAE, the situation is not considered force majeure unless the contract becomes impossible to perform. So it's not about difficulty. It's not about that it became financially unattractive. It has to actually be impossible.
What would have to happen for you to be able to, like in the future, let's say, give us a scenario in the future that you can actually say force majeure kicks in now?
So, for example, if DLD and the registration trustees' offices were not transferring properties, obviously then you can't carry through with it. If the banks stopped operating, they stopped transferring money, issuing managers' checks, etc. Or even if, for example, a lot of buyers were saying, well, I can't make it to the UAE because there were airspace closures, right? But we do have this option of remote notarization. And whether you are a resident, which means you can go through the notary public or a private notary, or even non-residents can go through the Ministry of Justice here in the UAE. So in that situation, it's not impossible.
So it literally has to be an event that stopped you from being able to do it, not inconvenienced, not, as you said, made it financially less attractive. It has to have been like, I cannot fulfill. And so an example of this, there was when the Strait of Hormuz was closed or blocked or clopen, as they're calling it, closed open to clopen. There was a company in Kuwait, I can't remember if it was the oil company, they declared force majeure because they could not physically deliver on their contract. That is a force majeure. Any other examples of a force majeure that is enforceable?
So force majeure, as Majdal said, that it's just have to be an occasion where it is going to be impossible to happen. So it's not just an inconvenience or the deal is just become a loss or something that is hard to get it done. In many cases where construction deals, for example, and in the contract, we have a specific date where the handover has to happen from the developer to the buyers. And because of the force majeure, there were difficulty in transportation, difficulty in the goods or the building materials to be available. And this happened for, I don't know, maybe 6 to 8 months, for example. And then it became impossible for it for a period.
Force majeure. Now let's get the buyer pulling out that everyone will have experienced. What's happening there? What are you advising your client? What are you advising buyers? What are you advising sellers?
So yes, we definitely have all seen that buyers were trying to pull out. Most likely it was because the financial unattractiveness or perceived financial unattractiveness once everything started happening. And so there were a lot of questions. And like I said, they thought they became experts, the legal experts, and all about force majeure. And you would see things like, so for example, one broker came to me and said, look, this buyer is insisting that it has to be force majeure. It was declared because Sheikh Mohammed bin Zayed, around March, I think 6th, 7th, he went to a hospital, he went to visit there, and he happened to mention the W word. And so that means that's it. It was declared, and now force majeure applies. And they were insisting on it. And I just kept telling them that it's, you can try, but then that 10% deposit is at risk. So it's not force majeure.
Okay. So in that case, then, Ahmed, is it just clear cut then, if you want to pull out of the deal, you will be forfeiting your deposit, whether you're the seller or the buyer? Or is there a scenario in which case there's some gray area? Can you let us know?
Well, I don't think there is a gray area. It's really very clear. The law is very clear. It says someone wants to pull out and the situation is not a force majeure. There is no way out of the contract. You have to exercise the contract as it is. So if there is a penalty of 10%, 80% of it goes to to one party and 2% of it goes to the broker. This has to happen. There are too many parties involved in the deal. If someone just finds it inconvenient for them because the circumstances of the market change and the deal is not as desirable to them because of the uncertainty that happened in their rate, it's not something that they can pull out from. It has to be a force majeure situation. It has to be very obvious one, because if they want to argue one day in front of court that this was a force majeure, they have to actually provide evidence, very hard evidence for that. And courts are very strict. They will apply the law, not circumstances.
One other thing that perhaps until this situation occurred, maybe many agents didn't realize that they didn't have waterproof clauses to ensure that even if someone does pull out, they're still receiving their commission. Ammar, do you want to touch on that?
Yeah.
Majdal, is that something that you're seeing where people didn't have the appropriate clause in their contract and you lose everything?
I'll leave the brokerage point to Majdal, but I wanted to point out something interesting, because if you just pause a little bit and we talk just at the general image that we're seeing here, we've seen these changes in the market, right, globally and in the region. Back in 2007-8, when the global crash happened, throughout, and then what happened in COVID, and then also now, and we've seen the development, and it's a pattern in a way that whenever there is a dip in the market, there's always opportunity comes as well, right? So, and we are lawyers, we love that, because that's why this is how we justify our existence, right? Look at situations like that and try to figure out solutions. What I wanted to add on that Form F contract and the investment, there's actually a certain scenario that we were involved in. It was very interesting, because I agree with everything Ahmed and Majdal said. But in one scenario, if you check the terms and conditions of the Form F, there's one clause: if the property is subject to mortgage. There's one, I think it's clause 18 in the terms and conditions, the first terms and conditions, that deals with I'm looking at it now, that deals with the final mortgage approved. So there are some cases, and Majdal, please jump in and correct me or add if I'm wrong. But what we have seen, that there are some cases where the deals are subject to a mortgage. The bank has to provide an approval on the valuation. And there's a 10% margin to that valuation. Technically speaking, if you have a situation whereby the bank comes and say, okay, you guys agreed on X for this property, but the actual valuation is now minus 10% X, technically the buyer would say, hold on a minute, I'm pulling out of this agreement, right? And this is an objective test. Well, I say objective. I've learned doing this job for many times that the majority of what we see is subjective, but let's assume it's objective, that the mortgage is based on an objective analysis of the property valuation scenario. Property is valued as 5 million, that the SPA says. Then the bank goes and say, no, actually, the valuation is now 4.5. This more than 10% on the value. Technically speaking, the seller can come and say, okay, I'm pulling out of this deal. We haven't seen it yet, but this is something we're currently dealing with, and I find it very interesting.
Actually, that's one of the clauses that should absolutely be added to the additional terms and conditions in Form F, or if you're in Abu Dhabi, because they are still using their own MOUs, you should definitely have that when the buyer has a mortgage, especially if you're representing the buyer, because if the valuation, first of all, if they don't get the final offer letter, there should be a clause that this contract is subject to the final offer letter being presented. And then the other thing is that the valuation should come in at the purchase price or X% below, then they can still, if it comes below that amount, then they can pull out of the deal, because, and what amount you have to put in, sometimes you see 5%, 10%, I've seen random 7%, but the buyer needs to do their own calculations, see what they can afford if the bank doesn't come back at the purchase price with the valuation, and then put that number into the contract so that they do have the opportunity to pull out of the contract if the valuation doesn't come back as they were expecting.
I might jump in here with a question to Ammar, because I had this situation with one of my clients. The bank, during the last few weeks, the bank changed their internal regulations. And they said, based on the actions and the market and how it is, the down payment for such property is not anymore 20% and is going to be 30 or 35%. And that is kind of a deal breaker for the buyer because they cannot afford it. So from one side, we have a seller who is upset that the buyer might have a chance to leave, and the buyer themselves don't have the approval from the bank. So they're relying on this to exit, while they did not do their own homework by going to 5, 6 other banks to try with them. Would you say that this is kind of force majeure or not? Because I actually don't have an opinion on that.
I was on mute, right? You know, the interesting part, the phrase "you are on mute" was quoted the most used phrase in 2020. I'm glad until now we still use it. Nice question, Ahmed. I wouldn't define this under force majeure. It should be purely a contractual point of view. In the case that I'm looking at the moment, the clause is clear. It becomes contractual. And Majeure said sometimes it's 10%, sometimes it's 7%, depending on the cases. So what people actually agrees on would apply in most cases. In my scenario, what happened is in the terms and conditions of Form F, it allowed parties, it was very slack. It was a very loose way of drafting. You can see like that wasn't checked by a lawyer. It wasn't assertive clause. The clause in my scenario says if the bank valuation came with less than 10%, it puts positions of both parties to renegotiate the price, right? But then what if they don't agree? There's no clause that deals with it, right? So I wouldn't say that that changes the position. That's why I said I agree with the status on the force majeure. I think it's on a case-by-case basis. Let me look at the clause here quickly. Yeah, yeah. In this particular clause, the agreement was if you go to your bank, get the valuation. If less than 10%, what we could do then? Let's sit down together and try to renegotiate a new price, and that's it. There's no further agreement. So then, what you can say, okay, we renegotiated, we didn't reach a price, and therefore I'm pulling out of this agreement based on this clause, which is not particularly a force majeure argument rather than a contract argument.
Yeah, I mean, as the non-legal person in the Zoom, I would say, look, this is the bank saying to the seller, your property today is worth X. So surely this should just be a discussion to be had with the seller to adjust their price, because it's not the buyer's fault, the bank that they chose, Surely. Ahmed.
Well, I go back to what Ammar said. It's at the end of the day, it's a contractual thing. And if one bank made their decision not to give a specific person a loan, or you have 100 banks in the UAE, you're going to have to knock all the doors until you get rejection from all. And then you go to court and argue that I did the best that I can to close this deal. And it was beyond my power or control. I couldn't get a mortgage or approval from anyone. I got the rejection from anyone, and then I would like to exercise the contract to pull out of the deal. So it is what it is.
And in the first episode that we did of the Situation Zoom, one of the suggestions that one of the CEOs had, it was Abdullah Al-Ajaji, what they said was they were now doing 5% deposits instead of 10, just to give that kind of flexibility. Is that anything that should be considered when it comes to that? Or would you say that's a good idea?
I wouldn't think the deposit amount, whether 5, 10, or even 20, doesn't matter really, because the contract terms are the contract terms. If the deposit is 10% or more, and if the penalty is 10% or more, it goes back to the contract. And if these common practices are not existing in writing, again, even if I don't have this particularly, it will go back to the common practice. 10, 5, or 20, it doesn't matter.
So wait, so even if you write 5% deposit, it would go back to common practice? No, if you agree to a 5% deposit.
No, that's not what I meant. What I meant is that it would not help one way or the other how much is the deposit amount. The deposit and the penalty are very much defined in the contract. With a 5 or 10%, it will be regulated by the contract. What the parties agreed on, this is what will apply.
There's also been, I did a leasing episode, and a suggestion in that one was that it was Zain Khoury actually. She said she's entering into 12-month tenancy contracts, but lightening being a bit more flexible with the early termination, notice periods, and so on. So with times like this, there's like new norms that come into practice. Ammar just said the most used sentence in 2020 was "you're on mute." So perhaps this could be the start of a new way of doing things. Like in the UK, we have 2-month notice periods, 2-month break clause with no penalty as long as you've done 6 months. Are we likely to see any adjustments in the typical tenancies or typical sales, anything that you're seeing a repeat of that you think this might end up getting adjusted?
It depends. I always see that the market we're dealing with is very, like I said, very subjective. I think one of the things I love about practicing law in the UAE, and particularly in Dubai, is just it's very agile. And the way I think of our job as service providers is really we adapt with what's happening around us. We are in the reaction side of things as a legal industry. We see how the market develops, and then we try to adapt with whatever needs there. It always keeps us thinking, lawyers. That's why we have a lot of anxiety and non-sleeping problems as lawyers. But yeah, I have no doubt that will be the case. If anyone will come and tell you and know how things will unfold, I will take this with a pinch of salt, because what we have seen is that we don't know what we don't know. What we know is things change. And what we know is that things develop, and it's based on the market actions. Things then start to fall in place, and our job is to anticipate the change, try to think about it, and give some indication of what could happen. But how things will particularly reshaped is something that we don't know.
You're known for your expertise in HR, employment law, amongst other things. So I want to tap into that side of things. And then maybe with Ahmed, we'll kind of touch more onto leasing and a bit more sales related queries, and with you as well, Majdal, on more compliance and training. So let's start with employment. What have you been hearing, seeing? What inquiries have you been fielding? Is it mostly from clients wanting to know how to let go of people in the right way, or is it mostly grievance cases where people feel that they've been wrongfully or unfairly dismissed?
Again, very mixed bag. What we have seen, and I think one of the reasons I enjoy what I do as a lawyer is like it's never. I always say to my associate, we are a tailor shop. We tailor services based on the client's needs. We don't have one size fits all. It has to be tailored on what are the issues, and having this mentality will get you exposed to different scenarios and how things actually unfold. We have seen employers, funny enough, have started their branching out to the UAE market before the regional developments. And we thought that will be a slowdown coming down the line, but that wasn't the case. They actually instructed us to look into their executives' employment contracts and the standard employment contracts, and how can we think of smart ways to attract talents, and how to make sure that these guys retain our confidential information, and how can we develop our remuneration packages. And that was interesting for me to see that push on from capital on still investing into finding the right talent. And that shows a belief system of how the UAE has managed to build an infrastructure that really sustainable enough that someone in the entertainment and hospitality industry is willing to still invest despite what's going on, knowing it's just going to be a matter of time until things adjust. So we've seen that. On balance, we've seen also other employers that just freaked out and said, we can't afford, our model can't afford to operate the way we operate at the moment. And we're not very strong on cash, and we can sustain, we're cash driven, and we can sustain our costs for the next quarter if we're not having the right revenues in place. And that resulted in a number of things, including reduction on salaries, 50% in some cases, particularly in the F&B sector. We've seen redundancies as well, scenarios that took place. We've seen delay on onboarding new employees. We've seen that as well. And that's on the employer side. On the employee side, we've seen also a mixed bag approach. We've seen individuals who reacted to what happened, and they decided just to leave. And that then resulted in terminating their employment because they were breached. They were unable to report to the office and come to the office. and that created a breach from their side. Because on the reality, and to be honest, I felt safe the whole way through, and my travel plans just got impacted a little bit, but just continued as normal. Right? Some people didn't react the same way, and that resulted in them losing their employment. They came for advices, and we're trying to help them, of course, but there wasn't much fruit for that regard. So it's a mix of bag, like I mentioned, depending on the industry, the employer, employee, how they felt about the situation, etc.
So where does the law stand when it comes to, let's say someone did leave the country and say, I'm going to work from home in another country, or they said, I'm too scared, I need to leave. Is it 7 days worth of absconding and then you're considered instantly terminated, or how does it work?
It's policy driven. It depends what parties agree on. If the employer is lean and happy for the staff to work remotely, that shouldn't be an issue at all, as long as there's an agreement. The conflict arises when the employer is asking the employee to report into the workplace. I mean, the UAE as a government made it clear it's work as usual. And I think that was a strong statement to just ensure that nothing is happening. We've seen even Saudi in the entertainment industry have actually pushed further on the entertainment and the events to be resilient and say, listen, we're going to continue with our life regardless what's happening. And I think that was a positive approach and definitely something that I personally resonate with. To be fair, it's a very subjective way of thinking. So other people would feel differently about it. When it comes to your question, I would defer to the agreement. What is the agreement between the employer and the employee? If there's an agreement that it's okay for you to work from home, then that shouldn't be a problem. If the employer insists on you coming to the workplace, you have to comply with that. That will be a legitimate request based on the UAE labor law and the underlying regulations. And if that didn't happen, then the employer would have the right to legitimately terminate the employment.
Okay. And what about salary reductions? Because as you mentioned, some even had to take half your salary, which makes life very difficult. So where do you stand when it comes to accepting? Because you kind of have to accept as an employee, you have to accept, otherwise you're basically terminated, or you know that another discussion will follow. And how can you kind of protect yourself to make sure that you, when times do get good again, you're able to get back that 50% of your salary that was deducted, shall we say?
I like how you framed the question. How I feel about it is I as an employer, I speak with my associate all the time. I'm quite open about how much money we make, how profitable the business is, how we structure the fees and all of that. And I'm trying to help them to become entrepreneurial in terms of how we operate as a business. And that always makes an easy discussion when it comes to things like that, right? So then they don't see it as one-sided, employer versus employee. That's me personally, but I'm not here to express my views. I'm here to comment on the law and what is the practice. Again, it comes to the agreement. Can the employer unilaterally reduce the salary? The answer is no, you cannot, right? But the question is then, as a reaction, what the employee is entitled to do is that they're entitled to file a complaint against the employer saying, listen, they are reducing the salary unilaterally, and I'm not happy with that. That might result in some sort of a compensation for the employee, but ultimately the employer will have to terminate the relationship. And with savvy employees, listen, if I'm working in the F&B and I'm seeing, listen, I used to serve 50 tables a day. Now I'm serving only 3. The employees who are sensible will say, listen, I'll take the 50% cut and survive to live another day. I like the employer. I like to stay in the game. And it's showing. It's not that the employer is trying to be difficult. I can see that the business got hit. So what do? Do I accept the 50% reduction and live another day and things might get better as you described it, Sylvia? Or no, I'm not happy with this. I'm going to protest it. I'm going to dispute it. I'm going to go and file a complaint with the Mahuri or the Free Zone Authority and take it up with the court. You can do that. But the reality of the matter, according to the new law of the UAE labor law, the employer can then terminate, and that will bring an end to your employment. Unlike France or the French law, the system here doesn't provide a re-employment obligation on the employer. And also, unlike the US is driven by capitalism. I can come and tell you, you're fired tomorrow and that's it. No, the UAE is more balanced between capitalism system and socialism system, and kind of try to weigh up both pros and cons between the both systems.
So is there a way that maybe an employer could claim force majeure if their salary was halved? Because it's impossible for me to come to work if I'm on half salary. Is there some room for some creativity in that sense?
Yeah, there's always a room for creativity. I never say no to creativity, but sometimes you're hit with the reality of how the world functions. As a business, I have costs to run the business, and I'm happy to take the punt for the next quarter. But if the business will take a slowdown, also bear in mind that summer is coming as well, right? So things are slowing down already. I will end up in a difficult situations. That how can I? Otherwise, I'll lose the business. It's either you accept the 50%, or me as an employer have to then bring redundant the business and close down. And this is something the employee doesn't want to see as well, right?
Yeah, but at the same time, I can empathize. It's technically like the employee is loaning their business owner half their salary. I'm financially supporting you. As if I'm working for you, I expect you to have a grip on this. I expect you to have enough funding or cash flow to not put me in this position where it's like you're paying me my full salary, but coming to me at the end of the month saying, can you loan me half? I might give it back to you when things get better, but I might also not. Do you know? Is that not?
I know, and I see the drive behind the question. I'll happily discuss it with you. I'm not going to shy away from it, right? Again, it comes down to the thinking. If you break down the line of thinking, that comes more from a socialism point of view, right? Of how the system should work, right? You as an employer have certain obligations to the people working for you. But the laws ultimately, as much as I can agree with you on a social level, I won't be doing my job as a lawyer to advise you on the legal framework and how things actually work, right? I am bound to understand the law, understand how these laws are being interpreted in the practice, and give you an opinion, not my personal opinion, my opinion on how these laws are being interpreted, how these laws are being imposed on both parties. And the reality is, I wouldn't look at it, and because I come from this point of view, I wouldn't look at it as a loaning 50%. I would look at it as a scenario whereby the employer wants to do two of two things. Either utilize the legitimate right to terminate the employment, which under the UAE labor law they can, right? Or renegotiate the terms with the employee and ask them to accept a 50% reduction and therefore a new bilateral agreement to reduce the salary from X to X minus. Can the employee renegotiate and come up with a structure that say, okay, how about this? Let me accept the 50% reduction, but how can you please recompensate me later on when things pick up in the future? Can you do a policy on the tip, for example? So there's always room for negotiation, right? But I'm afraid I have to end up with this harsh statement that I know it's not the most popular statement for the audience, but I'm a very emotional lawyer, but I'm also very, very realistic, right, with how things run. It comes down to the employer legal right to to exercise the right under the law by either terminate the employment or offer a reduction to live another day, and hopefully both of the employer and employee can benefit. I'm going to do it again. Sylvia, you are on mute.
That was me. Okay. Before Ammar drops off, because he has to go somewhere, but we're going to continue, Majdal and Ahmed and I. Ahmed and Majdal, any questions for Ammar before we let him go?
So what do you think about, so end of service is based on the current salary, right? So what do you think about the employees negotiating something in the agreement for the salary reduction that the end of service would be based on the original salary amount for some version of that? Maybe up to that date, it'll be the old salary, and then going forward, it would be the current salary.
Imagine that's why I like to work with smart people like you. Yes. And that's why you need to get a lawyer on your side, because this is a very smart question. It's a legitimate agreement to have between the employer and the employee, whereby basically you ring fence the end of service calculation based on the salary pre-reduction. So then you say, okay, I'm going to accept the reduction, but whatever end of service entitlement I got, that would be based on the original salary, not the reduced salary. And just for the audience benefit, the end of service gratuity is, I call it a loyalty scheme, whereby the employee gets compensated at the end of their employment based on how long they've been serving the employer and how senior they are, reflecting how much money they're getting every month. So the higher salary you get and the longer you stay with the employer, the bigger the end of service is. How much they'll represent, and also that the law says the end of service gratuity is calculated based on the recent salary the employees had. That gives a scenario if you start, let's say 21 with 1,000 dirham salary, next year is 2,000, third year is 5,000 dirham, 2026 you are at 10,000 dirham, the end of service gratuity will be based on the 10,000 dirham. Now, what Majdal present for us here is an interesting question. Now I'm 10,000 dirham. Now, as an employee, I'm going to accept a reduction of my salary to come down to 5,000 dirham. But then I'm going to accept the reduction for, let's say, 6 months. And then for the next 6 months, my salary is 5,000 dirham. What if the termination falls in place while I was at the 5,000 dirham salary? The bad news is the end of service will be based on the 5,000 dirham, unless you have a strong lawyer like Majid who can advise you and tell you, no, buddy, you need to ring fence your end of service gratuity. You have to have a clause in that reduction and say, okay, I'll accept the reduction, but I'm going to ring fence the end of service math on the 10,000 dirham calculation, which I think is a fair request to have. I'm really sorry for you guys and for your lovely audience. I have an emergency from one of our clients that requires my immediate attention.
Look at the dedication, the dedication.
You see,
Okay.
that's why I have to invest in my hypnotherapy and my therapist, because I need to deal with this anxiety that I'm living all the time, right? I need to detach from it. So yeah.
All right,
Sorry,
well,
guys, I
thank
have
you
to
so
go.
much.
It's been a pleasure talking to you all, and I'm sure we'll meet again.
Thank you. But just don't close your browser. Thank you so much, Ammar, for joining us in the Situation Zoom. And please come back when we're going to end up as, I've never done it this way before. It looks different. Okay, right. Let's move on to... Now, there's more stuff in sales, isn't there, that we need to tackle? Ahmed, what have you been posting recently? What's your most shared post right now?
Wow. Actually, one of my most posts, like shared posts, was the was about force majeure and deals, people trying to exit deals. Another one was about investor visa, because a lot of people opened companies in the UAE in order to get the investor visa, and they did not use these companies. And right now, the immigration department is checking everyone, because the tax authority and their taxes and their compliance obligations and so on. And when immigration find out that this company whole purpose was just to have a residency visa for the investor, and there's no income in it, and there's no transactions and no operations, they kind of give a warning to these companies and tell them, you either use the company or change your status, because you're not investing, you're not operating, you get a manager visa or something like that. So this was one of my most shared posts. And of course, I have the podcast, so I'm inviting a lot of lawyers to come and speak. Last episode was all about social media and media law, and what you can do online and what you cannot, and what you should not, and so on.
And I want to talk about that at some point. So let's what I want to do is sales, rentals, employment we've done, and then social media. I think that's it. Social media and what you can say, basically. And also one other thing that is I've seen also on social media recently, is this new thing. I don't know if it's new or if it was always the case, but any communication on WhatsApp is now deemed legally binding. Is that an old thing or is that a new thing? Can you just tell us where we're at with that, whether Majdal or Ahmed?
It was always the case since a very, very long time. Courts have agreed and discussed that the evidence is provided from the WhatsApp messages or any social media posts or sharing or any communication channel in general, as long as it's in writing and there is a defined technical way to verify that this information was actually transmitted from this person to that person, and the evidence is translated and given to court, it was always admissible and taken in consideration. So it's nothing new. It's just that from time to time, it just goes around the news that this is something new, but it has been the case for a while.
I know why I heard it, because a woman had WhatsApped her husband, I'm divorcing you today. And maybe she changed her mind the next day, but he took that and he was like, no, that's it. We're divorced.
It's very it's very common. It's not the first time. Some people who take their spouses to court, and it happens not just for divorce, for many other things. So possible.
And Majdel, anything else you're seeing on Form Fs with the brokers, trainings, perhaps any questions that you're being asked now in your Think Prop sessions that perhaps you weren't being asked before?
It's still very much, it is all about force majeure right now, whether or not the buyers can get out of the deals. So as we spoke about earlier, make sure that you do have, if you are getting, for example, a mortgage or you have a mortgage buyer, that there are clauses in there regarding the final offer letter, regarding the valuation amount, etc. Another thing that people need to be aware of is because in the Form F itself, so in the terms that are already there from the land department, it doesn't give an automatic extension for third-party delays. So if it's the banks, the developers, land department, a force majeure event that occurs, whatever it might be, that it's not there. So if something does happen, if, for example, it is a mortgage buyer and the bank just needs some more time to either issue the final offer letter, or the final offer letter was actually signed and they haven't had time to do the transfer before the Form F expires, then it's technically the seller could pull out. And I've seen that situation, especially when the market was hotter last year, where maybe the seller got better offers and they wanted a way out, and they were this close to transfer. You know, either the final offer letter was pending or it was just signed, but they didn't do the transfer yet, and the seller wanted to back out. So they were saying, no, we're not going to renew the Form F. So the thing is that you need to make sure you have that clause as well, because that's something else that could potentially happen.
Okay.
I
Anything?
wanted
Yeah.
to add one point that is very important to what is happening right now, because of course we are here to give you the legal insight and all the legal information, but this is something that we deal with every day. People have to take care of their emotions when they decide, their emotions when they buy, when they sell, when they sign. Take a moment, you know, this is tell to all my clients, just take a moment, slow down. There's no need for you to react very quickly. The market is hot. Just take a moment, go to a strategic real estate advisor to show you the statistics and the numbers. This situation is not unique. There has been a few wars in history. There has been a few economic downturns in history. There's been a few real estate bubbles in history. If you want to look at investment, you have to think strategically. It's going to take you 1 or 2 hours. It's going to cost you $500 to $1,000. Amazing. But just cool down, get the advice, and then decide. And before you sign, do the same exact exercise. If you're looking at real estate or any financial investment, do the same due diligence that you have. Before you sign a contract, read it thoroughly. Ask a lawyer, you know, take your time. There is no rush. And usually we see all the problems is not happening because there is a bad contract or there is a missing clause. Everything is usually there. Everything is done by the book, but still people do mistakes because they don't read the contract that they just signed. The problem is not the contract that has been passed illegally or illegally. It's just that the awareness, the level of awareness and the level of calmness that the people have when they sign a contract or when they make a decision whether to go here or there. And this would be probably the best advice, whether legal or investment. Just chill, take a bit of moment, have a minute before you make an emotional decision.
But in response to that, the reason why people don't read their contracts is because you lawyers make it so small, 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 small. Why do you do that? If you want it to be read and dissected, make the font match the rest of the document. You're doing it on purpose.
In my defense, first of all, if I want to really protect you, should I put or not a force majeure clause? Because I'm not talking about you, but 90% of the people who never heard the word force majeure before a few months ago. If I tell them I need to put a force majeure clause in the contract, then it's going to take me a little bit of 15 minutes extra to read the document and then assess the commercial transaction and then extend the force majeure clause to be 4 paragraphs. It's going to take me half an hour extra. And this half an hour extra is going to make the contract, instead of 1 page, 2 pages and a half.
What
You
about,
wouldn't like it. I have to put the contract in a small font and explain it. And then why is the force majeure important? Why do I have to put a penalty because the deal is going? Why are you investing so much time in this? It's because of these situations, because I've seen it. I've dealt with it, and I know if the contract is not constructed in a proper way and it was filled up correctly and it was checked 1 or 2 times, occasions happen. And when they happen, you have thousands of people crying in the streets thinking that I used a very bad conveyancer, I was misleaded by a broker, or the developer hides something from me. It's like you yourself putting millions behind your investment, and you don't want to invest $500, $1,000 behind a legal advice and then blaming the lawyers from putting a small fine print.
you know why?
Sorry.
You're going to hate this. I run them through ChatGPT and say, give me the headlines, give me the bullet points. What do I need to be aware of? I'm going to go on mute now. I'll let you two fight it out.
I'll leave this one to Majda.
No, absolutely not. ChatGPT is great for certain things, creative kind of things, getting ideas, but not for legal. Absolutely not. I mean, it gets it wrong all the time. It misses things. As much as I've tried to train, for example, on my courses, it still will get things wrong that I've told it a million times, right? So if you're relying on AI for legal at this point, maybe at some point it would be perfect, but at this point, absolutely not. You're probably going to get in much more trouble. So yes, I would not encourage people to use ChatGPT or any other AI.
Okay. All right.
I bet anyone listening to this episode right now, just ask ChatGPT to give you 10 reasons why you should drink coffee every day, and ask ChatGPT to give you 10 reasons not to drink coffee every day.
Mhm.
And in both scenarios, you're going to get amazing 10 reasons that will convince you. So if you really want to rely on ChatGPT to be your doctor or your lawyer or your mentor, good luck.
I like that response. I'm gonna ask my ChatGPT. I'm sure it'll prove your point perfectly. Okay, moving on to tenancies. What's the most popular issue that's being brought to you right now?
Well, what we saw a few times right now is that everybody wants to negotiate the rent, thinking that the rental prices have went down dramatically, while on all statistics, and I show that rents did not really go down. Maybe in short-term rental, it was affected a bit because of the level and the number of tourists who are in the city or in the country as at large, but everybody wants to negotiate. And the legal element here is that also there is a time frame where you can negotiate. It's always in the contract that you have to provide a notice of 90 days if you want to do any changes in the contract as a landlord, and the same time 90 days as a tenant. So if you're the tenant and you want to reduce your rent and you're less than 90 days in the contract, you cannot even exit the contract and you cannot discuss to reduce the rent.
Or change any of the terms?
Or changing the terms, or even say that you are leaving, because you have to look at the contract. If you want not to renew the contract, you have to give 90 days notice before the contract lapses. If you don't give the 90 days notice, it's assumed that you are already going to renew the contract. However, some contract says, even if you want to renew the contract, you have to give the 90 days. So what applies in this scenario? If you did not say I will renew and did not say I want to exit the contract. So if you want to exit the contract, you will get to exercise the clause in the contract that applies the penalty. So if the penalty says 2-month penalty and 2-month of notice, you're going to have to serve both. Maybe it doesn't say and it says or, between this and that. So you have to really read the contract very well, because sometimes it's a penalty or notice, and sometimes it's a penalty and notice. And if you don't read the contract before you sign it, which means every year ago, most probably, or probably several years, or you did give it to ChatGPT and ChatGPT told you, yes, this is a standard contract standard term that looks perfectly fine, you can go and sue ChatGPT. Maybe they will help you.
So I had understood it slightly differently, and correct me if I'm wrong. And it's more applicable to UK law, that where you also have to give notice at the end of the tenancy that you're going to leave. But in certain scenarios where someone left on the last day, they were considered to have fulfilled their contractual obligation. They have a 1-year contract. So even if they didn't give notice and they left on the last day, it's okay.
Unless there is a clause in the contract that says if you want to terminate the agreement at the end of it, you have to give notice. Or if you want to renew the contract before it lapses, you have to give the notice. So it really depends on each contract and how it is drafted. So if there is a notice defining the action or the occasion where the notice is required, it's understood that you have to give the notice, because I would argue as well as the landlord side, and I say, I did not give the notice of the termination. Finding another tenant will take me 2 to 3 months to secure that. This is a material loss of money. If I would have known that you are terminating the contract 3 months in advance, as per the agreement, I would have secured another tenant, because this 3 months means money for me. And because the equivalent rent in this area, in this property, with this view, with these conditions, with these facilities means $30,000 per month. And this is $90,000 of loss. And based on that, I'm going to ask you to compensate me for that loss because you did not exercise the contract.
Okay. And my next question on rentals is renewals. So at the moment, it's based on the real rental index, which sets the price. But let's say you've got the real rental index, which is taking, the history of rents, comparable rents, rather than the current situation. So if the current market price, let's say you're in a 2-bed in downtown and real rental index says 150, but you know that the market price right now is 110, 120. Do you have a leg to stand on, a negotiating tool, or you just have to move out and move into that 120 unit?
I'll take from a dispute side and then I will pass it on to Majdel for this one, okay? In the courts, we saw everything because it's really on a case-by-case basis. We saw all kind of verdicts in different scenarios when it comes to residential, commercial, retail. It was all different than the others. But in general, the court might be considerate if the situation remains bad or remains in downturn, or there is a big discrepancy between the index and the market, if it is prolonged for a very long period. But for example, what we have right now is that all the airports are open, all the schools are open, all the malls are open, everything, life goes on normally. I wouldn't say that the court will consider any change in this scenario, but then I will pass it on to Majdel for a comment.
So it's really important to remember that while there are rental increase caps per the rental index, there is no right to a reduction. So if the market does go down, it's just really up to the tenant to do their calculations and see, is it worth it for me with all the expenses and having another commission to pay and the new security deposit, et cetera, to move somewhere else, or should I just negotiate with this landlord and get as close to this amount that they're asking for now? So it's really up to tenants to do that because they don't have the right to a reduction. The other thing that I want to point out is that with the exception of the 90-day notice for any changes in the contract terms or the rental increase and the 12-month notice or any kind of eviction notice that is under the law, everything else is really dependent on the contract itself. So if, for example, we've been seeing people who want to get out of their leases because some people want to go home or they can't afford it anymore because they've had a salary reduction or they've lost their job, whatever it might be. There needs to be a clause that allows for early termination because the law is silent on early termination under the tenancy laws. So if you don't have it in the lease, then you are going to be at the mercy of the landlord to let you out. And if it's not there and the landlord is not nice enough to let you out, then you may be liable for the remaining term of the lease. So make sure as a tenant that you always have an early termination clause, and make sure, obviously, per our earlier example of 2 months notice and 2-month penalty, that it's very clear that, it's either or, because you don't also want to be stuck doing 4 months, basically.
Well, I'd say it's equally as important for a landlord to make sure that they've got an early termination penalty in their contract, because in a scenario where your tenant ups and leaves the country, they don't care. The tenant doesn't care, but the landlord is not going to be able to re-rent it until that tenant releases the unit, right? So it's in both parties' interest to make sure that there's an early termination penalty. Have I got that right?
Absolutely, yes.
And try getting repossession of a property when the tenant is abroad, has probably changed their number and, uncontactable, unreachable. So that would be another court process. Okay, anything else on rentals? Or should we move on to social media and digital laws and communication and stuff? Because we'll move on. There was a lot of sharing of stuff on WhatsApp. Ahmed, can you just tell us what to avoid and what to just where do we
It's
draw the line?
one of my favorite topics. I chair the Emirates Legal Network for a few years, and I manage the online communication channel that we have, which is a WhatsApp group. We have more than 600 members, and very often I get this because I have this responsibility, because I'm the founder and I'm running the association. I'm more sensitive than others on what is shared and what's circulated and what comes in here, because we have a big number of people, because whoever receives this might reshare it. And if this is not really verified information, the law is very clear. We have articles in the cybercrime law that penalizes people for posting, sharing, and sharing the same penalty for them for anything that is unverified or fake, or I don't know, let's say rumors that might hurt society in any way that the government or the authority might see, because of course they see much more than what we see, or even confidential information. So sometimes people see something on the street or in the sky and they take a photo of it or a video of it and they share it. They feel like, I'm not sharing false information or any rumors, not knowing that this could be very confidential information. And this confidential information can harm someone whose their job is just to protect your sky or protect your home or protect your family as well. So it is very serious. I've seen people getting verdicts of deportation of the country just for sharing unverified link of something that they saw on social media. And then later on, it was classified as rumor or as confidential information. I know people who are in jail just for taking photos or videos of sensitive places, thinking, oh, that's just a fire. It's a smoke in the sky. I'm going to make a video of it because I would like to document this moment for my memory or for my family, or I just shared it with my brother. You have to be very careful. Everybody needs to understand and to familiarize themselves with the cybercrime laws in the UAE. I just issued by Nagoro Partners for us, I issued a media law guide that guides all influencers and everybody who is online, basically, who is behaving online. They have a podcast or they have just basic social media and they're sharing it. Everybody should read this media law report because it's really important for everyone, because your online behavior is not the same as your behaving in your, I don't know, living room at your home where you close your door or close your curtain and you feel in private. I just shared the information. That's not the case anymore. When you're online, you're in public.
And it's a big responsibility. And which is why this show will never be live, because even afterwards, after we record, I listen to everything once. And if there's something that just sounds a little bit off, I'll either check it or I'll kind of, but sometimes I'm just like, no, I'm reaching my own conclusions. But can you just be super clear? Like, I avoid anything that's blasphemous, anything that's talking negative about the government or the rulers, rumors is one. So yeah, there was an episode I did before. They spoke about a potential, something good, a rumor that was being circulated, which was positive. It was a positive rumor. But I just thought, well, that's still a rumor. It's not verified. So I'm going to remove that from the episode.
Yeah, absolutely. And it is very sensitive. I mean, I had this argument with one of my friends before because she was sharing official news from an official government source, but it's not the UAE government. It's an official government source from another country who was attacking us, for example. And they say like, oh, it's the official channel of this country. And I'm like, yeah, of course. What do you think war is? I mean, if there is any conflict or any armed conflict between two countries, they will also attack you with media. So it's not okay just because the BBC have shared it or because the official news channel of another country in Africa that is shared. It means that you can share it clearly because this is sensitive time. It's not peace and is not 100% free to share any information. You have to be very careful with the information you share it during sensitive times like this. Verified information means the official news media of the state where you live, because they are the ones who are taking care of your own safety inside. And do not reshare media material that is not published anywhere because you don't know its source. You don't know if it's real or not. You don't know if it's AI generated or even altered with any kind of technology. You have just to stay away from anything that is unverified or issued from media sources that does not belong to the state or vetted by them.
Clear. Okay, so both of you have quite a large real estate following and you follow real estate brokers, agents, likewise. Just give us a couple of examples of things that you've watched, reels that you've watched or posts that you've seen where you've been like, don't do that, especially coming from the real estate community.
Okay. For me, I felt so bad for everybody who was talking very negative because they just created panic for themselves and they created even a higher burden on themselves to defend their wrong ideas, because it's really a thing right now. And you say, my opinion is that the prices will go down. And then when the prices don't go down, you feel like, yeah, just wait, because you have to automatically defend this not very smart idea. And the other people who were like just copying whatever they hear on the negative news that they share on social media, because this negative media that does not help anyone. So whether it is true or not, or it might create some panic. And I was always saying that even the negative news that is correct, it should not be shared very widely because it creates panic, and this panic creates emotional decisions that are actually the worst enemy to any investor or any real estate broker or anybody who's working in this field, because the only correct way is to look at the market, look at the numbers, look at the past few years. If you're going to lose, you're going to lose anyways. But real estate as an asset and as an investment class is not a short-term game. So if you panic and you run away quickly because the prices are dropping today 50%, think again. You're not in the right business.
I know what yours is probably going to be, Majdel. The
Mine
cash,
is kind
the
of the
cash
reverse,
ones.
right? Mine is kind of the reverse ones about the cash, yeah, the AML stuff always. Don't post. So there was somebody actually who posted that they had a good week. This is just before actually everything started. They had a really good week on LinkedIn and they were like, Alhamdulillah, we had a good week. And then they have all these piles of cash, a picture of the piles of cash. And then somebody said, oh, I'm pretty sure AML won't like this. And I was like, oh my God. I told him, I think you need to attend my AML courses. He did not show up, but yeah, definitely don't do those kind of things. And also, I just think in general, you just have to be careful. I mean, whether it's positive or negative, like you don't also want to put something out there, like you said, Sylvia, that's going to age badly, right? So there's a lot of things that are probably going to age very badly out there. So you just have to be very careful about that.
Yeah, which is why I've done the situation room, because usually, I mean, Majdel, my stuff is quite polished. We record and it's evergreen and we post it and you can pick up and watch it 2 years later and it's still relevant. But now I was like, no, things are moving. I need to be posting live, and then in a couple of weeks things might change and I need to get people back and hear their sentiment. But I also don't want people to feel like they can't come on and talk about how they feel about the market, what they're experiencing. I mean, Ahmed, where do we draw the line as podcasters?
First of all, we have to make sure that everybody have the space to say their own opinion and they can talk based on their expertise. People are free to express themselves in the right way. And at the same time, we as podcasters have the responsibility of providing them the medium. So if I don't like what my guest is saying, I have the full right to cut it or to delete the whole episode or to keep it as it is, and they are responsible of their own opinion. Many times I had to record and delete the episode because I don't like, and I just, sometimes I don't tell anyone. I had to lie to the guest and tell him we lost the recording. We will have to record back again. I'm going to give you a call. Never call them again. But at the same time, I'm taking care of myself and my business, and I will never, ever give platform or a medium to anybody who is saying wrong information, unverified information, or someone, to be very honest, who's always negative. I'm a very positive person in general. If you ask me at any certain day, how do you do? I will tell you, I'm fantastic, because that's how I feel. That's how I want to feel. And I will never tell you, So, for example, all my
Not like
guests are
me and
smiling
Majdel.
people.
All right, question for you
Somehow I
then.
made it on his show, though.
I missed that one. I didn't see it. Okay, question, because again, maybe my lack of legal knowledge. I thought that the podcaster has the responsibility for anything that is aired on their platform. Likewise, if you create a WhatsApp group, it's the admin of that WhatsApp group that takes legal responsibility for what's being shared and communicated. Is that the case?
Well, yes and no. Yes, they are responsible. There is a certain level of responsibility. Everybody who's providing a platform or a medium or a network for people to talk or to express themselves, there is a certain responsibility. But it always is like also compliance. What did you do about it? So your responsibility comes when you say, I have 620 people who are talking 24 hours on Emirates Legal Network Association, the WhatsApp group, okay? I cannot control what everybody feels every day. My job is to put the regulations, to apply the regulations, and to remind people, listen, there is this rule, there is that rule, please delete it, please do this, please do that. If I'm caught or the network is caught with someone who shared information without me doing my job of making good governance or trying to reduce the risk of spreading this rumor and so on, then I would be held liable. Of course, my liability has a limit to my actions at the end of the day.
Well, that's really good advice. So anybody who is the admin of a WhatsApp group, make sure, no matter how small it is, even if it's just the family group, create some community guidelines and put it on the front page of the WhatsApp group. Okay, I think I've taken up plenty of your...
Since we have this very nice platform and we are giving advices to people, I'm going to give advice to everyone, because it's very often that everybody's using WhatsApp and they're muting a couple of groups and archiving a lot more. Just wanted to let you know that legal possession in the law does not differentiate between the possession of illegal materials on your WhatsApp that you know about and the WhatsApp that you don't know about. So if you're on a group and they're sharing illegal material, and this illegal material is accessible to you, there's a slight small chance that you might be held liable for having access of illegal materials on a WhatsApp group that you don't know about, or you probably didn't see. You muted them or you archived them, but it's happening in the background that the people are talking and sharing information, false, wrong, or even illegal material, or some illegal transaction happens there, and you are part of this community and you have access to it, please be very careful, because you might be liable to that. So if you don't want to be on a group get out and delete it. If you don't want to receive some information from other people and you're muting them or you're archiving them, get out, because whatever is shared there is in your possession because you have access to it.
Well, that I never knew. So that's a fantastic golden nugget. Thank you, Ahmed. Majdel, have you got any closing golden nuggets?
So what I would say for brokers, and this is coming from me as both a broker and a lawyer, you really need to don't just sell the property, actually understand the deal, and you have to shift from being a salesperson to being a trusted advisor. So knowing the laws and regulations, the deal flow based on what type of deal, if it's cash, mortgages involved, off plan, etc. And also you probably want to learn more about how VAT and corporate tax are going to be part of the real estate deal. Even a lot of clients, especially after this situation, they are asking more and more about wills. They want to have wills, right? So know what their options are. I'm not saying become the expert. We don't want you to act as a lawyer, right? We don't want that. But at least know the basics enough to educate the client and then refer them to somebody who can take it further with them.
Brilliant. Thank you so much. Will you come back?
Yeah, if you want us. Hopefully everybody will have time to do it. No emergency.
Hopefully not, but yeah, no, that was really useful. Thank you so much, Majdel and Ahmed and Ammar, who had to drop off midway through for an emergency. But yeah, I look forward to hosting you back in the Situation Zoom. Thank you very much.